the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. Please be seated. We have 3 cases set for oral argument today, and we will start with design gaps versus distinctive design. Mr. Hess.
Thank you, Your Honor. If it pleases the court, my name is Todd Hess. I do represent the appellants in this matter this morning. I have reserved 5 minutes of my time for rebuttal. What we're here to argue this morning, Your Honors, are the dismissals in this case from the lower court based upon res judicata and collateral estoppel arguments using an arbitration that was associated with this matter. Of course, we're not claiming that you can't have res judicata or collateral estoppel with respect to arbitration matters within arbitration, but the rules...
How about an unconfirmed arbitration award?
Unconfirmed, and it's interesting, Your Honor mentions that. We did have finally a hearing last week in South Carolina concerning whether it would be vacated or not. We're still awaiting a decision on that. So, but Your Honor is right. It has not yet been confirmed.
So where we are just factually is it was confirmed by the district court, that was vacated by this court, the parties went to state court, with one side asking the state court to confirm, one side asking the state court to vacate. You had a hearing, but there's been no ruling. That's just factually where we are right now?
That's correct, Your Honor.
Thank you.
Yeah.
So with that, I mean, before we leave that issue, do we have to decide, as it factually stands now, a unconfirmed award is different than a confirmed award for purposes of res judicata collateral estoppel, aren't they? I mean, there's law out there that talks about that, but a lot of this preclusive law is for full faith and credit purposes. So I don't know that you have full faith and credit issues arising from an arbitration. There's some law that allows it just with an unconfirmed arbitration, but that's a question. I mean, I know this all happened after y'all briefed, so I'm not, complaining, but does this make any difference to us? I mean, do you have are you going to argue this? Do we have to decide whether unconfirmed arbitration award, because that's where the status is now, is sufficient for this preclusive effect before we even get to the decisions? Should we wait? What should we do from your perspective?
Yes, Your Honor. The appellants actually do agree that we should wait, that there was a lot of issues here with respect to a...
And just to walk through, again, I just want to make sure I have this completely. We all agree that if the award were vacated, it would have no preclusive effect whatsoever. Like a vacated arbitration award gets no preclusive effect. We agree on that?
That's correct, Your Honor. So, and that's basically what I'm here to argue today, whether res judicata and collateral estoppel should apply with that.
Well, you briefed it as if it was a confirmed award, and that's, you got some issues with that, but right now we actually have this interim status that's odd, that it is unconfirmed. It was confirmed at the time, you briefed it. We're going to have a decision presumably pretty soon. I practice in state court, South Carolina, so sometimes those happen fast, sometimes they don't. But, in the not too distant future, there should be an answer. But it can be different, obviously, whether it's unconfirmed like it is now, whether it's vacated or it's confirmed.
That's correct. And the judge that heard it last week did indicate that he could probably get us a decision within a week, but unfortunately, we've still not seen that yet. So we actually do not know. So
what is it you want us to do now while we're waiting around?
Well, I could argue why we think it doesn't apply in the event that it is.
Even if you lose in state court, why you think there's not preclusion?
That's right.
Right.
That's right.
Probably
So,
helpful.
So with that, with respect to that, as Your Honor had indicated, if we do lose in state court, notwithstanding that, there are preclusive effects, obviously, because it's not a ruling. I mean, even if it does win, though, from that standpoint, we believe that the dismissals based upon res judicata and collateral estoppel should not apply. With respect to the res judicata rulings, those were based upon, well, there were two cases. One case was based upon one of the parties that was identified, that was not one of the petitioners, if you will, within the arbitration, but the respondents to the arbitration.
Could you be a little more specific? Give the name. I mean, rather than talk generally, just
Sure.
go right to it and tell us who you're talking about so we know what's going on.
So the claimants in this case were Shelter and two parties, the Highsmiths. Shelter is a design company that was managing
Right.
some upgrades to a house that were owned by the Highsmiths. My clients were the respondents within that arbitration. That was Design Gaps, and David and Eva Glover, which were the owners of Design Gaps. So those were the parties here. Notwithstanding those parties, though, there were involvement of quite a few others with this. One of those people's name was one by the name of Jenny Butler. She had testified that she was not at all associated with Shelter, but she did actually have, with respect to some of the things that were happening within, over the course of the period that involved the design, basically, if you will, design plans, architectural design plans that my client actually had copyright to. She had passed those off on to somebody else who was, they were bringing in to do the work that my client was doing.
She gave them to Distinctive Design, so.
She did, that's right. So that's why we had a claim in this suit against her based upon vicarious and contributory infringement because of her case in passing along those designs.
You have several of those claims, and that if someone wasn't a party to the arbitration, and particularly when you sought to include them, some of them, I think you sought to include and weren't allowed to, that means you should have no preclusive effect.
I'm sorry.
So the issue I think that comes from that is that's not an automatically showstopper in terms of you can't have preclusive effect. You don't have to have identity of parties if you have privies. What's your argument that, whether it's, the Hightower estate versus Hightower, or whether it's a Butler versus Shelter, there's not privity?
Well, when the respondents in that case did request that the arbitrator name Jenny Butler and Distinctive Design, as you had mentioned, as well as their owner, Brian Wright of Distinctive Design, the arbitrator ruled, the respondents had requested that they actually be named third-party respondents in the arbitration so that at least his claims against them could perhaps even be brought up. The arbitrator, though, ruled against that, as you had alluded.
Well, because the arbitrator said arbitration is a matter of contract. This individual is not a party to the contract. I can't force people who aren't parties to contracts to arbitrate things, right?
And that's exactly what the arbitrator
Which
said.
seems unambiguously correct.
Right, that's correct. And
So my question is, given that, why aren't they privities, why isn't there privity, or are they privies for purposes of claim preclusion, res judicata, all that stuff?
we believe, appellants believe, and it's actually in part based upon a decision that was made in a Northern District of West Virginia federal case where it was decided that if a party was decided that they couldn't be named in the arbitration, they couldn't be a party that would be held in privity with that decision. So that's the position that appellants have taken.
That seems to, that's interesting, because that would seem to, that's a pretty big ruling. That's obviously not binding on us. And is there any appellate court law on that issue, sir?
Unfortunately, Your Honor, nothing that we found in the Fourth Circuit, and that decision from the West Virginia was not appealed, so there was no decision on that otherwise. But we do feel
And
like
what's the
that.
name of the opinion you're talking about in West Virginia?
That was La Rosa versus Pecora. It was actually an unpublished opinion, though, back in 2009.
So an unpublished district court decision from West Virginia.
That's correct.
And that's probably why it's not in your brief.
It should be in my, I think it is in the.
Oh, okay. La Rosa versus what?
Pecora.
All right.
That's just interesting because
It's
if we weren't in arbitration, I mean, if there was a separate case where the parties weren't there, you would not have that rule, right? I mean, the law's pretty clear, you don't have to have identity of parties, and I'm trying to, just from how the rule works and why would it be different for arbitration versus if it was a case in court?
Well, there's two issues. One with respect to the res judicata, we believe that the arbitrator, through his decision, did not give respondents an opportunity to discuss anything, if you will, with respect to Jenny Butler. But yet the arbitrator did make a decision with respect that there was no copyright infringement. That goes to the collateral estoppel issue with respect to Brian Rice and distinctive design. The collateral estoppel issue, if you will, pretty clearly relies upon, based upon Fourth Circuit precedent, relies upon the state rules with respect to whether a decision should be considered preclusive or not. The primary factor that needs to be determined there is factor 5 of that collateral estoppel test, and that's whether the party was foreclosed of prior resolution of the issue of fact, had a full and fair opportunity to litigate this issue of fact in the prior proceeding. This, we do not feel that the appellants had a fair opportunity to litigate this in the prior proceeding.
Because the person wasn't a party?
Because the person
But
was,
I guess I'll just go back to what Judge Quattlebaum said, that just seems to be fighting the notion of privity, because if people are in privity, they're treated, a person or an entity are in privity, they are treated as being literally the same.
but we think that privity effect got removed, if you will, in this respect, Your Honors, and that's, again, primarily because the arbitrator removed them. It did not,
I just don't understand how the whole KSF Act, so the general rule is you can only get claim preclusion if the parties are the same. But what it means to be in privity with someone is, even though lawsuit 1 was X versus Y, if X and, X1 are in privity, then it is treated as if the initial lawsuit was between X1 and Y. That's what it means to say that X and X1 are in privity.
yeah, but it was the notion, at least of the appellants at that time, when, like Jenny Butler, with respect to the res judicata and privity argument, was named, that the arbitrator had actually determined that she could not be a party, if you will, to this
Why would
lawsuit.
the arbitrator decide if they're in privity? The district court decides if they were in privity.
It does, but we feel like that the decisions made by the arbitrator in this case is the one that actually foreclosed that opportunity to name her.
Is there something about her and her relationship is with Shelter, right? Ms. Butler and Shelter, I mean, that's the connection.
That was the connection that the court made, Your Honor. Yes, that's correct, but it was not the connection that actually existed based upon the testimony of her now deceased husband.
So you got two issues I think you could make. One, it seems like you're saying because you weren't allowed to bring them in, that's enough. But that seems hard because that almost eliminates the privity concept. The other thing is you could say the district court was wrong in declaring or deciding they were in privity. And it sounds like you have an argument on that too. Could you say what that is?
I mean, again, if there was really no connection, stated connection at all that Jenny Butler had to Shelter, which was one of the claimants that the decision was made in favor of within the arbitration, then...
Isn't a company owned by, I mean, it's a company that she and her husband own?
Well, her husband owned it at the time, was the testimony that we got within the arbitration. For some reason, they wanted to make sure that Jenny Butler was not at all connected to Shelter. We don't know the reason why, but the testimony of her late husband now, obviously, unfortunately, was that she was not really connected at all to Shelter, was the testimony that we got in the arbitration, Your Honor. So we think that testimony there itself does remove her at all from that decision from Shelter for some reason, that they wanted her removed. So, I don't know.
You're getting close to the end of your time, but I want to identify an issue I'd like for you to be prepared to talk about on rebuttal, if you would, and that is an issue that's not briefed, and it's the effect of what you said of Mr. Butler's death, and what if that creates any issues for us. I mean, I know there have been some notices filed, but I don't know if there's been an order issued, and I'm trying to see if that creates some complications for this appeal.
And yes, Your Honor, and I'll be happy to address that during my rebuttal time.
All right, thank you. And I did find that case, Mr. Hess, in your reply brief.
All right, thank you.
Ms. McDonald?
Good morning, and may it please the court. I am Andy McDonald, representing today the appellees. Design Gaps and the Glovers are essentially asking this court to bend the rules of procedure and equity to allow it to go back in time and change some decisions that it made.
First of all, do you agree we should wait to do anything till we hear about what is happening in state court with arbitration?
I do think that we'll have an answer on that shortly, so potentially you won't have long to wait. However, my research in South Carolina, there is nothing that says an unconfirmed arbitration award does not have preclusive effect.
But certainly you agree that a vacated arbitration award has zero preclusive effect.
Yes, and that was.
And it remains possible that the South Carolina court will vacate.
It is
I mean, it
possible,
could.
yes.
Okay.
So if this court would like to wait on their decision until after that is resolved, that is understandable, so that the issue of whether an unconfirmed award does not have to be addressed.
Because among other things, would the question be whether South Carolina law would give an unconfirmed arbitration award preclusive effect? I think it's whether I actually think that's itself a choice of law question, because as Judge Quattlebaum said, normally speaking, when we're talking about preclusion, it's because of full faith and credit, and the full faith and credit statute, the full faith and credit clause, the full faith and credit doctrines are about courts giving preclusive effect to the judgments of coordinate or sister courts, not about federal courts giving preclusive effect to, in the eyes of the law, the arbitrator is some guy who resolved the parties' private disputes. And I'm not aware of any doctrine that says federal courts give preclusive effect to some guy's decision.
So I believe you raised two issues there. So first, the question of whether state or federal preclusion law would apply. Initially we briefed arguing that federal law would apply, and that was because the district court at that time had confirmed the award. At this point, that has been...
But if state law applies in federal court, it's only because federal law decides that state law applies in federal court.
Yes, and the Fourth Circuit has stated that when a state judgment is...
Judgment, that's a really important word you just said there. Judgment. An arbitral award is not a judgment. An arbitral award is some guy saying X has to pay Y money. That's not a judgment.
Fair, and I'm speaking in terms of if it is confirmed by the state court.
Sure, agreed, 100%.
So we should just wait, right? You said, we don't have, it's pretty rare when we get opinions out like the day after an oral argument, so isn't this a little bit academic?
I would say waiting is probably the best course of action, since there's no disagreement on the impact of the outcome of that state court decision. And the judge did represent that he would get that order out quickly.
Do you have you heard me raise a question of Mr. Butler's death?
Yes.
I don't know that we have a order of substitution from state court. Do we have a notice of death, and does that create a problem for us?
So it's my understanding that appellants have not challenged the dismissal of Mr. Butler, the claims against Mr. Butler in this appeal.
Mr. Butler died in the pendency of the action, and
Yes.
normally something has to happen so that someone is representing the estate, and there was a notice of death. I don't know if there was a motion for substitute, and it looks like that was filed and it just proceeded without it being acted on. And, there was notices again filed in the Court of Appeals, but the way that rule works is it's only for deaths that happened during the pendency of the appeal. And look, this seems, I know y'all been going on a lot, and, it seems like a fairly, ministerial sort of thing, but I'm wondering if it's an important ministerial thing.
Well, our position would be that Mr. Butler and his estate, at this point, his estate was never added within the 90-day period in district court, because that case was actually resolved before the 90 days
Well, it
ran.
wouldn't be adding, it would be substituting. It's that when a person dies, the estate just becomes what was the person, right? I don't think you have to add an estate after someone dies.
So after a notice of death is filed, in district court, you have the, Design Gaps had 90 days to file to request a substitution of parties, and if that is not done within 90 days, Mr. Butler would be dismissed.
So you think, okay.
And they didn't do that.
They did not do that, and they did not do that in Fourth Circuit either, and I believe, but I can verify for you,
So that happens just effectively, he's dismissed without an order? Is that how that works? I mean, I guess it was dismissed at the end in conjunction with the rulings on motions to dismiss and summary judgment on res judicata type grounds. So he has been dismissed. You would say by operation of Rule 25, he should have been dismissed probably earlier from a procedural standpoint, but he has been dismissed. That's interesting.
Yes,
Right.
and we can file a motion requesting his dismissal to get that order entered. However, in the opening,
How can he do that? Does the district court have jurisdiction to do that right now?
I meant in the Fourth Circuit, I apologize.
Yeah, but you can't do it in the Fourth Circuit because our rule, I think, talks about deaths during the pendency of the appeal. Maybe we can, I don't know. All right, I thank you for that issue.
And I'll just add on that point quickly, I don't know that there is a practical effect, just because none of the dismissals of claims against Mr. Butler are on appeal here. And I addressed that in my brief as well.
Before, one more table setting thing. This is a merits preclusion question, but it's one that's not brief, but is bothering the heck out of me. Do you know any authority for the proposition? So, in general, claim preclusion has an absolute mutuality of parties requirement. Agree. B, I agree that if you're in privity with someone, you can be the victim. I'll just use this loosely. Like, right, preclusion there's always someone who wants preclusion and always someone who doesn't want preclusion. And I definitely know that you can be the victim of claim preclusion if you're in privity with someone who was a party in the previous proceeding. It seems a little weird to say that someone who wasn't a party in the first proceeding can get the benefits of claim preclusion on the theory that they're a privy of someone who was. And I will not purport to have done an exhaustive deep dive, but that seems a surprisingly hard question about which there's not a lot of authority. Obviously you think, I presume you think the answer is you can, but what's the argument for why you can? I sort of understand your friend on the other side's, in the intuitive force of his argument to say, the idea behind claim preclusion is, we all did this. We had the arguments, and anyone could make any arguments they wanted to make, and then we're done. And just because you thought of a new argument, a new theory, a new claim later, we had the time that we were going to do that thing, and we're done. And no one gets to make arguments now that weren't made then, or claims now that weren't made then. And I get that completely when it comes, as somebody's the victim of the preclusion, like, you lost, and the person you're closely affiliated with, they lost too. It does seem a little intuitively weird to say in a situation where they tried very hard to add someone, the arbitrator said, for reasons I think are right, I literally can't. That party that didn't participate in the arbitration despite your friend on the other side's attempting to make them participate in the arbitration can then get the benefits of claim preclusion in a suit in which they weren't a party, the other side tried to add them as a party, and weren't able to do so in part because the party that is, that's another way to think about this, the party that is now seeking to take advantage of claim preclusion resisted efforts to make them a party to the previous proceeding. That just seems weird.
So, and this is an issue actually that I addressed in the related case where the appellants were seeking to vacate the arbitration award. And that was one of the arguments that they raised, although in the context of distinctive design, so collateral estoppel. But here, it was in...
And I get it in the context of issue preclusion, I'll say that, because in issue preclusion, we've long since accepted there's no absolute mutuality requirement. So this problem doesn't really come up in issue preclusion because there generally isn't an absolute mutuality requirement. But claim preclusion, there is a mutuality requirement.
Yes, and I apologize, I lost my train of thought.
You said in the previous case you addressed the question.
Yes, thank you. So it was within Design Gap's power to enter an agreement with Shelter to set aside claims that it wanted to reserve to pursue against Ms. Butler individually. And that has been done in the past. I can try to find that case. It's in my other...
I can play a brief from the previous case.
So say that, I'm sorry, before you go, will you repeat? I didn't quite get
Yeah, so
that.
Design Gaps had the choice to pursue those claims against Shelter that it could have brought against Jenny Butler separately. And all they needed to do was come into an agreement with Shelter to sever those claims and agree that it would not be precluded by the arbitration. And likely Shelter would have not agreed and the arbitrator would have been involved. But that was a procedural option that was available to Design Gaps, and they did not pursue that. So that addresses a bit of the fairness concern that you had.
Yeah, but what about my more conceptual? This just seems odd, given it's odd to say that a party that wasn't legally a party to the previous proceeding can invoke the benefits of claim preclusion. And I haven't been able to find a case that squarely says they can. I mean, there are cases that say there's no mutuality. The problem is it seems like most of the cases about privity that I've been able to find are about issue preclusion, not about claim preclusion.
I would agree with that, but just putting yourself into Ms. Butler's shoes. She already funded the defense of these same exact claims based on these same exact facts.
It strikes me that Ms. Butler has a great defense, but that's 12b-6, not issue preclusion. Like, it's not me. The person who did all the bad stuff they're accusing of happening, I was doing in my capacity as I mean, obviously her first order view is I didn't do anything wrong, but her second order view is to the extent that I did it, you're accusing me of doing anything wrong, every single thing I did wrong was in my capacity as an agent. Your claims against me fail under Rule 12b-6. They're just wrong, not preclusion.
Well, we did also raise that argument in district court, but district court found the arguments of res judicata more persuasive. We also argued collateral estoppel in the event it didn't quite fit into the privity framework.
Because once you go to there, there's no privity requirements anymore.
Exactly. But the district court believed that res judicata was the best fit for the situation, and that was based on the reasoning that Jenny Butler was in privity with Shelter, and the case law, I agree with you, I haven't found a case specifically addressing this circumstance. However, it has not made any distinction between which side of the person using or defending res judicata is on. So the same thing applies for Casey Highsmith as in her capacity as trustee versus her individual capacity in the arbitration. Again, there was privity between...
That seems easier.
Yes, well, and the allegations directed at Ms. Highsmith as an individual and as a trustee were basically identical. And so the argument that those allegations are not related to the contracts and the performance at the Highsmith residence sort of rings hollow.
So do we, this may relate a little bit to Judge Hyten's discussion. The claims against distinctive design for copyright infringement are deemed to be precluded, as I understand it. And I think I understand it to go like this. There was a claim that of copyright preclusion in the arbitration, and the arbitrator found that the explanation that they did not use those designs, any similarities were due to space constraints and things like that to be the reason. And then that finding, goes to whether there was any infringement at all. So it, carries over and is precluded from being relitigated in this case. Is that kind of how it goes?
Yes, so Design Gaps chose to bring those indirect copyright claims in the
right.
arbitration, which
Yeah.
necessarily required a finding of direct infringement by distinctive design. So
So-
that issue was decided.
Yeah, I mean, and let me just say, I find that merits-based, copyright decision kind of, interesting, if not dubious. I suspect, though, the answer is, when we're talking about arbitration awards, the standard for, challenging the substance of something is extremely high.
Exactly, and assuming the award is confirmed,
Right.
really at this point, we wouldn't be talking about the merits of the decision. It would just be what was decided and what is precluded.
Well, there is some way to challenge the issue of award, but you're right, if it's all confirmed, that's bottled up in that decision.
And I believe Design Gap's main argument in support of not applying collateral estoppel is the full and fair opportunity to litigate issue. In the brief, Design Gaps argued that it was not afforded procedural opportunities that it would have been otherwise. So I just wanted to clarify, Design Gaps did have the opportunity to pose Mr. Reese and did question him in the hearing.
Can I switch gears to a single issue that is not res judicata collateral estoppel? And it's the, if I understand it, it's the breach of contract claim for unattributed use for the, I think, Bailey house that seems like if it occurred, it was within the statute of limitations. Period, so it's not barred. As I understand it, the district court held that was waived. And, I'm familiar, I read all about the back and forth, the cease and desist threat, and the fact that there was no action taken after that. And that just seems like to say there's, it seems like at least plausible to argue that something like waiver, that is where we're not expressed, we're talking about implied, that there's at least a question of fact as to whether that was a, zero, issues about whether something was waived, when they never said waived, they didn't sign anything that was waived, and we're, attributing something pretty significant to them.
So I have 2 points in response to that. First, this was on a motion for summary judgment, and Shelter provided evidence in support of its claim that the rights to enforce the promotional use clause had been waived. Design Gaps provided.
But that evidence was that back and forth a few years ago about other claims where they ended up not seeking a cease and desist letter about what's going on with other stuff when their relationship was a little better.
So it was that back and forth communication.
Or
It
not,
was,
I shouldn't say better, but it probably was better, but not good.
so it was the back and forth communication, but also the continued relationship between Design Gaps and Shelter. So they continued to work together on contracts that were not subject to this lawsuit. And so that implied that they, with full knowledge that Shelter was continuing to post on their website, continuing to post in these magazines, they were still working with each other, and that clause was still in all of the contracts, but not being enforced.
Can you kind of say, look, I mean, this stuff's going on, we're working together, I don't like it, but it's, overall okay with me, given the, benefits and, burdens of everything else. But once the relationship goes south, I can still bring a claim that I've not officially waived. I mean, That just seems like a lot to get to the waiver for me.
Well, I am not aware of, and Discovery didn't reveal any conversations like that about some agreement that that clause was still enforceable.
Well, I know there's not an agreement, it's just someone can have that in their head.
Oh, and that was the second point that I want to make. This issue of waiver is analyzed under an objective standard, not a subjective. So all evidence that Shelter was seeing was that Design Gaps was not planning to enforce this promotional use clause. It threatened to, but then absolutely did not, and was just silent and continued working. So objectively, they had waived their rights.
Thank you.
And quickly, the summary judgment order, that should also be affirmed on the basis of latches against the Lanham Act claims. And that was based on the back and forth communication, the threat of litigation, and then failing to file a lawsuit within the time period allowed. And Design Gaps relied heavily on Whataburger in its briefs, and I just wanted to distinguish that quickly because I'm not sure I did that very well in my brief. But Whataburger involved two companies, the company in Texas and the company in Virginia. And so I'm not tongue twisting myself, I'm just gonna refer to them that way. So the Texas company became aware of the Virginia's company use of the mark 30 years prior to filing its suit. However, it had not expanded to the Virginia market until shortly before it filed its suit. And so the Fourth Circuit's point there was that 30 years ago, when it first had notice of the Virginia mark, it literally could not file a suit because they weren't in the same geographic area. And that is not the case here. And I'm about out of time, so if there's
You are
one more
out of
question.
time. Thank you.
Thank you.
All right, Mr. Hess?
Thank you, Your Honor. As I'd promised, with respect to the death of Ryan Butler, we had been notified by opposing counsel that he did, in fact, pass away upon a trip that he had with his wife, some vacation trip or something like that. It was opposing counsel, not her, but the other gentleman that handles that had indicated to me that, or asked me if we wanted to go ahead and just dismiss him altogether from the lawsuit. We did have him named individually, but also as the owner of Shelter. We did have Shelter that was continued to be named, and we also had the indication from that opposing counsel that Mrs. Butler was assuming ownership of Shelter. So we felt like that we had all the parties involved that should be involved, probably already encompassed, as opposed to naming the estate of Mr. Butler in the complaint, filing a motion to do that.
So my question, though, was if there was no action taken on the notice of death, does that present any issues about whether we have a final order situation? And you know, your colleague says, well, by operation of law, if there's no action taken after 90 days, someone is, dismissed. We don't really have an order on that basis, but we got the later order of dismissal, and seems to say, look, that given all that we have effectively everything you would have if you, by operation of the rules on this. It sounds like you don't really dispute that, or do you dispute that?
Well, I mean, I do dispute, we did have other parties named. They remained viable, if you will, with respect to being parties to this litigation that we had filed. So we felt like they continued to be covered. It was really just Mr. Butler himself that we felt like we didn't need to take action with respect to his estate, because we did have Shelter named, and we did have Mrs. Butler named, where there was an indication that she was assuming ownership of Shelter anyway, to me. So based upon those indications, we at least chose not at that time to do anything in addition to filing a motion to name the estate of Mr. Butler as opposed to him within the litigation, Your Honor. So, but yeah, the answer is we do not think that it affects, if you will, the other parties. In fact, their effect becomes changed a bit, in particular since Mrs. Butler apparently was not had no ownership, or at least was not named an owner at the time, but it was indicated to me that she became an owner at least upon the death of Mr. Butler. Did want to go ahead and address the, with respect to what, the waiver issue that Your Honor brought up over the course of my opposing counsel's arguments. We agree. I mean, each of the contracts were actually entered, if you will, on an individual basis for individual projects. We think that those promotional use clauses continued to carry through, notwithstanding, as you had indicated, when the parties were cooperating more, they chose not to go ahead and enforce those. There were letters written. We did put those within, before the court, that the letters indicating that they shouldn't do that anymore. They provided reasons, either apologizing, opposing counsel, or opposing parties provided reasoning that they apologized for doing that, or their reasons that they ended up doing that.
But they kept doing, the problem for you a little bit is, number one, you didn't expressly reserve it. Number two, you kept even after the cease and desist letter, it continued, and you didn't take action, up until then.
Right.
So,
well, of course, my clients were basically relying upon the shelter and the other parties for business. They didn't want to compromise necessarily that business relationship, if you will. Basically, they hoped.
Why isn't, I kind of raised the situation, raised an argument, that might be in your favor, but, why doesn't, from an objective basis, that, create an indication that because of that business, maybe good reasons, I'm not going to burn the bridge yet?
Yeah.
And not burning the bridge is effectively waiving it.
Well, they didn't continue, they didn't ignore it, obviously. It was brought up before shelter, it was brought up before Mr. Butler at the time, that they were doing that and that they should cease and desist with respect to that. There was a cease and desist letter. And I see my time is up, so unless Your
All
Honor-
right, thank you. Thank you
Thank you.
both for your arguments. We'll come down and greet counsel and proceed to our second case. Oh, sorry, everybody. Please be seated. I didn't know y'all were standing. All right, we're ready for United States versus McComer. And Ms. Weeks?
Good morning, Your Honors, and may it please the Court. Crystal Weeks on behalf of Appellant Jackie McComer. With Your Honor's indulgence, I'd like to take just 2 minutes to set the table for the 3 issues I want to focus on this morning, which are the spreadsheet, the jury instruction, and the prosecutorial misconduct. Each is emblematic of the same core defect in this case. Our criminal justice system rests on a simple rule. The burden of proof in a criminal case never shifts from the government to the defendant. The government tried this case as if the opposite were true. The burden shifting was no accidental mishap. It was the government's entire trial strategy. From the outset, the government made this case about on-site versus off-site time. It anchored its case in a purported summary spreadsheet that highlighted Ms. McComer's off-site time as presumptively fraudulent and deliberately excluded evidence of Ms. McComer working. This on-site, off-site framing worried the district court judge. At the close of the government's case in chief, the court expressed concern that the government's charts might give the jury the false impression that if Ms. McComer was off-site, that she couldn't be working. The court set out to instruct the jury on this issue, and that instruction, which was read 3 times to the jury and emphasized as very important, only further reinforced the burden shifting. The jury was told that it could only consider Ms. McComer's off-site time if it found she was working off-site. That flipped the default from a presumption of innocence that her off-site time was to be presumed valid to a presumption of guilt. That her off-site time.
So what is, in thinking about that, I read that in the briefs and certainly agree with the proposition that the burden's on the government to prove beyond a reasonable doubt. But can something be factually, let me just say, unusual or less obviously related to the contract? I mean, from a factual matter, if I said I did my work, every night between midnight and 7 a.m. I mean, that could be true, but that's kind of odd. And if you pointed that out and had evidence that I sleep a lot during nighttime, I mean, is that really shifting the burden or just saying this is a little bit unusual? Most of the work here is expected to be done on site. You have a whole bunch off-site, and, they point out other evidence. I guess I'm raising the question of if something is suspicious, arguably, why can't they point out that it's suspicious and that not be part of the meeting their burden as opposed to shifting the burden?
Well, Your Honor, we don't dispute that the government can certainly point that out and the jury is entitled to draw inferences, but here the inferences were unreasonable. The government said up front that this should be a full-time contract for the program manager. There's no evidence that Ms. McComer did not satisfy her obligations as a program manager.
Well, she should at least be working when she's billing for work, shouldn't she?
Correct, Your Honor, and
The court found that in its Rule 29 order found, there's a long list of times when she's billing for 8 hours, but doing things like going to music festivals, driving her daughter to college, going to hair appointments.
Well, the college example, Your Honor, Ms. McComer testified that she didn't actually go on that trip, and that's the inherent problem with this spreadsheet.
And the jury heard that.
Correct, Your Honor, but that's the inherent problem with this spreadsheet, which was clearly an illustrative aid and told the jury. This was taken back to the deliberation room with the jury, and they were told to consider this as evidence on equal footing as the other exhibits.
Can I ask you the elephant in the room question about that spreadsheet?
Yes, Your Honor.
Did you ever object to the admission of that spreadsheet on any of the grounds that you now advance in the district court?
Your Honor, to be sure, the argument has varied on appeal, but Mr. Allers.
Okay, so
the no.
am I correct that every document summarized in that spreadsheet was admitted without objection?
That is correct, Your Honor.
And do you have any authority for the proposition that says once a document's been admitted, it can be used for literally any purpose unless there's an express conditional limiting ruling? It's in. Once the documents are in, they're in, right?
The documents are in, Your Honor, but this spreadsheet, we think this is plain error. In the McGuire case, we submitted a Rule 28 letter on, says that.
There was an
so.
objection in McGuire.
Another defendant objected, but I believe that the court there applied plain error because it found, like you're implying here, that the objection varied and was not on the same grounds.
Didn't the court also find that there were actually mathematical errors in the chart in McGuire?
That is correct, Your Honor. Just as the court has acknowledged here, there are a handful of errors, but says that shouldn't throw the baby out with the bathwater.
Are there mathematical errors here?
No, Your Honor, but there are errors in the evidence that is submitted on this spreadsheet. There are times when the government put on here a credit card charge and highlighted it in yellow, which was theirs.
So I don't mean to cut you off because I've read that and I think it's fair to say there's some errors there. And I think we got to question that as whether the errors are sufficient. I don't think the law is that if there's an error in the summary, that makes it automatically inadmissible. So it seems like you have at best, you have plain error on accuracy. Then you have plain error on the shading. And then you have plain error on the descriptions, okay? Assume I think it's a hard row to hoe on the first two, that the accuracies are, are enough to satisfy plain error, and that the shading is enough to satisfy plain error. But perhaps the comments aren't a summary, but are excerpts of the favorable information.
Cherry-picked
Yeah.
favorite clips.
If that's true, you still have to overcome prejudice in a plain error review. And all the documents from which those, as you say, cherry-picked language come from were themselves admissible. And I think, and I think admitted, maybe not. But can you really show prejudice when the information in the comments, which I think is your best argument about the spreadsheet, were themselves admissible, could have been used and pointed out, could have been used as a demonstrative? And I know you think putting all that together is worse for you. I may disagree, but does it really amount to prejudice and, prong 4 of plain error, which, brings into question the integrity of the judicial system? It just seems like you got a hard row to hoe since we're looking at this under plain error.
Yes, Your Honor, 2 points on that. One, I don't think that the comments can be disentangled from the color shading, because what the color shading did is it told the jury what conclusions to draw from the cherry-picked comments.
No, that's your argument, but the shadings identified off-site work. And that's back to the other burden-shifting argument. That's an objective thing. Maybe I get you. Maybe it did, but an argument is objectively the shading shows where the work is being done off-site, which at least creates some suspicion given the circumstances, at least in the government's mind. Maybe that is. Maybe that's not technically a summary, but that just seems not nearly as strong as the argument about the comments.
Well, accepting that the comments are error, Your Honor, this spreadsheet, and I think this is a very important point, was the government's entire case. We counted this spreadsheet was mentioned 161 times in the presence of the jury, 14 times in closing alone. At 5 different points in closing argument, the government told the jury to, quote unquote, look at this spreadsheet when you're deliberating.
That makes it all, maybe this is probably prong 4, the way I'd operationalize this. This makes it all the bigger problem that none of these arguments were raised before the district court, because the whole idea is, look, you have some arguments that maybe the color is misleading. Like, this all should have been sorted out, because if this had been raised before the district court could have said, you're right, page 5, that's inaccurate. Government, you have to change that. But now we're in a world in which we had a trial, this spreadsheet was extensively relied on, and no one objected, and you're asking us to throw out a criminal conviction based on I get it, but I suspect you're different counsel on appeal. These are great arguments that could have been made to the district court, but the fact they haven't been made to the district court really complicates things here.
Your Honor, and that is correct, we weren't trial counsel, but the court understood that this spreadsheet could be misleading, and she should have struck it. It shouldn't have gone back. It should have been a minimum been given a limiting instruction.
Did you ask for one?
No, Your Honor.
Has this court ever reversed for a failure to give a limiting instruction that the party that would benefit from the limiting instruction never asked for?
Not that I'm aware of, Your Honor, but I still think under plain error.
Okay, can I take you to a different instruction question?
Correct.
So the burden shifting instruction?
Yes.
Why isn't that dead bang, not just forfeited, waived? Because defense counsel literally said on the record, that instruction is fine with me. And I know that I've written one, and I know we have other opinions that say, when you say things like that, it's not just forfeited, it's waived because you have consented to the instruction.
Yes, Your Honor, and we cite the Rosa case in the Third Circuit where counsel there also said, I'm satisfied.
I have written a
understand.
Fourth Circuit case that says
I understand.
that waives your objection.
I understand, Your Honor, and in the interest of justice, this court can still consider
No.
issues.
If it's waived, it's gone. Something that's waived is gone.
Your Honor, we still think that the
Unless it was
instruction,
ineffective assistance of counsel, but that's not the argument you've made.
Correct. We did not raise that on direct appeal. But this instruction can still be considered if you're looking at cumulative error. And
No. If it's waived, it's not error. A waiver eliminates the error.
Your Honor, if you find it's waived, there's still the spreadsheet is plain error, the burden shifting comments on cross-examination of Ms. McComer. Just because a defendant takes the stand, their constitutional rights do not go out the window. The comments and questions of Ms. McComer when she was on the stand that asked her if she had come into this courtroom with evidence to prove her innocence shifted the burden, and that's a constitutional error, Your Honor, and then the burden shifts to the government to show harmlessness beyond a reasonable doubt, which we do not believe they can do.
Where is there a JA site for the government asking her if she could prove her innocence?
Yes, Your Honor. Well, this is the quote. Have you called in this case a single?
What's the J?
Oh, excuse me, 2671 to 72.
Oh, my God, have it. Okay, go ahead.
The government asks, have you called in this case a single witness who has come in this court and testified that they observed you working as the program manager on the Iron Bridge contract for an extended period of time? And that was after they also asked her, I was asking if you had shown any records to the jury demonstrating that you were providing these status reports. And our position is not that the government cannot ask questions that lead the jury to draw inferences or that question the credibility of the defendant. But once that shifts to what have you brought into this court under Parker, under St. Louis, that is suggesting that the defendant has an obligation to prove her innocence.
How does that intersect with, there are lots of cases about burden shifting. Many of the cases about burden shifting involve defendants who don't testify.
Correct.
But this defendant got on the stand
That's-
and she made assertions that things were true. And I'll say my 20,000-foot overview sense is that the government, no defendant has to testify. And if a defendant doesn't testify, they have an absolute right. They can literally, I don't have to ask a single cross-examination question. I don't have to call a single witness. I can do all those things. But my sense from the cases is that once the defendant takes the stand, and once the defendant makes affirmative assertions of fact and asks the jury to credit them, the government's allowed to attack those assertions of fact. And one of the ways the government's entitled to attack those assertions of fact is to say, if the things that you are now asserting were true, it seems very likely that there would be other evidence of them being true. And the absence of that other evidence suggests that maybe what you're saying is not true. So why isn't, do you agree at a high level of generality that that's true?
I agree with that, Your Honor, and that's
so why
not.
is what happened here? Why is what happened here?
Because that's not how they framed the question.
Okay.
They framed it as, what have you brought into this courtroom? If Ms. McComer had said, I'm innocent, which is effectively what she was saying when she said she worked off-site, they couldn't have said.
Hold on. That's not just I'm innocent. That is my alternative, affirmative explanation for why my timesheets aren't lies.
That speaks directly to an element of offense. It's not like Parker, an alibi, where they were able to say, is there anybody who can testify that you called your sister?
But if the government had asked, do you have any documentation to prove you were working, would that be okay?
That would be okay, Your Honor, but saying you've not brought into this courtroom anything to show the jury after we're already dealing with the presumption of off-site work being invalid and the jury instruction that was considered.
I can see the difference in those two questions. Have you brought anything in the courtroom that shows you were working during those times? But it's not a huge difference between that and saying, do you have any documentation to say you're working? It's different. I get it, and I get it. And look, I got some questions about some things that for your colleagues there, but that's not a ton of daylight in those two things.
It's a fine line, I think, in many of these cases, Your Honor, and I agree. Many of them deal with defendants who don't take the stand, but in each case, the courts are saying this is a fine line, this is borderline improper.
But why isn't that, once you say it's a fine line, why isn't that ball game on a forfeited argument? That once you say something is a fine line, you have failed prong two.
Your Honor, if they step over the line, just as in Schmitz, which is the government's favorite case.
His point is, it's got to be plain, and if it's a fine line.
Yeah, under prong two of Alano, you can't get relief on a forfeited error unless it's clear or obvious. And once you tell me it's a fine line, and once you tell me that those two questions sound very similar, I don't know how it's clear and obvious error.
Your Honor, saying to the defendant, have you come into this courtroom with any evidence to prove an element of the offense that is clear error, and then it shifts to, okay,
And
this
then
is
they
not a...
argued a similar thing in closing argument to the
Correct, Your
jury,
Honor.
correct?
Correct. In closing, they said the defendant has not provided any evidence. And
But speaking of evidence, why isn't then this, I mean, this was a 16-day trial with 18 government witnesses and the defense put on a case. Why isn't the cumulative effect of the entire trial remove any prejudice from those isolated statements
Your
from
Honor.
the prosecution?
we think the cumulative effect of the entire trial only reinforces that the trial that was guided
Well,
by
but the
this
jury
spreadsheet.
didn't think that. The jury,
The jury took this
Found her
spreadsheet, this
guilty.
roadmap to the government's argument into the deliberation room with them after the government laid 22 pages of it on the courtroom floor during closing and told the jury, quote unquote, "Do you see that blue? That's an ocean of fraud." And then they went promptly to deliberate. And it wasn't close. It took over 9 hours for them
Right.
to deliberate.
and then there, well, 9 hours isn't that long on a 16-day trial with all of those witnesses and materials. And perhaps it would be different had someone objected, but they did not. And your time's up, but you have some time in rebuttal.
Thank you, Your Honor.
All right, Mr. Clayman?
Yes. Good morning, Your Honors, and may it please the Court. William Clayman for the United States. This is a straightforward government procurement fraud case in which Jackie McComer billed the government for exactly 8 hours of work, day after day, over the course of 19 months for work that she was not actually performing.
How is the right-hand column where you claim evidence that I think is probably admissible, but is your best evidence from a bunch of documents in any way, shape, or form a summary? It's not a summary. It's what you like out of all, maybe those documents. I mean, a summary is a summary. It's not a summary of the best evidence for you. And this isn't even a summary of the best evidence. It's all the best evidence for you. Now, I don't see how that comes close to being a summary under the federal rules of evidence.
Understood, Your Honor, and a couple of points in response, if I can. I think, first of all, when the agent was asked how he put together this spreadsheet, why they put it together, he did testify this was meant to summarize voluminous records, that he was just, in the notes column, putting forth exact, precise quotes or very short snippets from the many voluminous records that he collected throughout the
So he's just getting some examples, a summary, so he's got some, where are the summaries that are not harmful to the defendant? Because if you're summarizing, presumably you got a sample of everything. It seems to me like we don't have that. We got only the bad stuff.
And a couple more points in response to that, if I may, Your Honor. So in terms of including exculpatory and inculpatory evidence, I think the agent was asked during his cross-examination, he included, for example, an allegation from the whistleblower letters saying that Ms. McComer had gone to a golf tournament on a certain day and therefore could not possibly have billed 8 hours. And then right below that, they included a letter from Ms. McComer's counsel specifically denying that that had happened. And so that's
So you think this fairly represents all the exculpatory and inculpatory evidence, is that right?
I think the agent selected evidence that was helpful to the government's case, for sure. I think they did also include some exculpatory
I guess I will
evidence.
just say, from this judge's perspective, you should be darned lucky they didn't object to this spreadsheet because, like Judge Quattlebaum, I am profoundly skeptical that this is admissible substantive evidence. This looks like a closing demonstrative. In fact, the ocean of fraud makes clear it was being used, to me, as a demonstrative aid, not as substantive evidence.
I understand your point's well taken, Judge Haytens. I think they did not object to this spreadsheet at all. They conceded.
It's really
to
good
that.
for you that they didn't.
Yeah,
Sure.
And let me, while I'm there, the statements at closing arguments about would this amount be a material to you are things you learn in Trial Ad 101 you don't do. I mean, it's not like just one error here. It's, I think the questions that were raised about, bringing things to the courtroom, it seems like this prosecution has stuff going on that, is obviously not appropriate. Now, there should be objections, and when there are objections, they'd be ruled on, but it's not just one thing.
Understood, Your Honor. And before going to those, the pecuniary interest remarks, I think that
Right.
you were referring to, I did want to make one more point regarding the spreadsheet, which is that the spreadsheet was provided to trial counsel in advance of trial. As I think Judge Heitens mentioned, all of the underlying records were admitted at trial, and so the trial counsel for Ms. McComer could have and did in fact press the agent about these asserted omissions, right? I think trial counsel did bring up some emails that they thought were helpful for Ms. McComer and pressed the agent, why didn't you include these? So that all was all aired in front of the jury. And the judge, Judge Hollander, instructed the jury, when you go back to your deliberations, you'll have the spreadsheet, but you'll also have the underlying records in the testimony, and you should refer to those records to the extent you have concerns about the spreadsheet. So I
So
understand.
you may have a prejudice issue that helps you, that maybe there's harmless error, maybe it's not, some of it's not plain error, but anyway, if you want to talk about the comments at closing, and, or do you think those are appropriate?
Specifically, how about this one? There is no evidence that's presented in this case, and the defense had the chance to present whatever evidence they wanted to. JA 3051. Why isn't that just a dead violation of cases like Stockton?
I understand, Your Honor, and I think, if I could, I think what the AUSA was responding to there was the affirmative case Ms. McComer put on, where she talked about how, as a program manager for Iron Bridge, she was routinely meeting with people from outside companies.
So now you're telling me what you think the AUSA was doing, but let me ask a threshold question. Was that a proper statement?
I'm sorry, if Your Honor could repeat it.
There is no evidence that's been presented in this case, and the defense had the chance to present whatever evidence they wanted to. JA 3051.
Again, I think in
I'm sorry, that's a
isolation,
yes or no question. Is that a proper statement or not?
in isolation, I understand that sounds improper.
I'm not.
Sounds, it is.
It is improper. I understand, Your Honor, and my point is simply that I think the comments weren't necessarily made in isolation. I think the AUSA was trying to respond to what they saw as
It seems like you might need some remedial things you're allowed to say in closing training.
I understand, Your Honor. And I would note a couple of things as well. First of all, they did not object to that comment in closing arguments. This was actually brought up with the district court, Judge Hollander, before closing arguments. She, assessed what they were planning to say and gave them the okay.
Well, I mean, look, you have the non-objection question. I'm pretty confident, maybe if you want to point to a JA where the statement Judge Heitens raised, or the statement about wouldn't this be material to you, was that cleared with the district court, those specific statements?
I don't think the exact quotes. I think the gist, they were going to comment on what they had asked
Right, they were
her
going to say
about.
what I explored with your opposing counsel and say, look, the defendant got on the stand, and when she got on the stand, she made claims, and when she made claims, we can point out the problems with the claims we made, and they were allowed to do that. I read Judge Hollander saying, of course you can do that, you can always do that, but I agree with Judge Quattlebaum. I don't see anything in the transcript where Judge Hollander says these are things you could say in closing.
Understood, Your Honor, and I don't think there is anything to that effect in the transcript. The other thing I would point to, on top of them not objecting to this comment, is that the jury instructions made clear, as well as the prosecutor's closing argument, I believe the same AUSA said, we have the burden of proof. Judge Hollander then repeatedly instructed the jury that the government alone bears the burden of proof. So I understand Your Honor's concerns with some of these comments, but I think given the lack of objection, given the standard of review that we're operating under here, I don't think they've proven plain error.
And does the government, you said you understand our concerns. Does the government itself have concerns with some of the comments that were made, both in cross-examination and in closing argument?
I think the questions during cross-examination towed the line. I think that the AUSA was.
It also sounded like a burden-shifting question as well. I mean, you can ask those questions without, in a different way. But what were you getting ready to say about the closing argument?
I was simply going to say that I think these were a handful of comments. I think we were talking about 6 questions during a very lengthy cross-examination, 4 or so remarks during a very lengthy closing argument during an even lengthier trial. So
Right, I know that in this case, for your argument here, the cumulative effect and the fact that they didn't object helps you in this case. I'm just talking about in your office, do you have a concern with it? I was in AUSA for a while, and I messed up all the time. We all do, and every Monday morning, we'd have meetings where we would have lessons learned about how we messed up. So is there something like that hopefully going on in the U.S. Attorney's Office in wherever you are?
So I'm actually not from the U.S.
Maryland?
Attorney's Office, so
Oh.
I'm sure there are post-trial debriefs about issues that occurred. I'm sure the briefing on appeal.
Where are you from?
I'm from Maine Justice, Your Honor.
Well, that's even better then. Does Maine Justice have any concerns with this type of closing argument?
I think in our view, Your Honor, that they towed the line. I think some of them
In
were
closing argument, you already said that, you already in
I thought we
answer.
just said they went over the line in closing argument at least once.
I think the comment Your Honor read, I think in isolation, yes, I can see that is not, that is,
You can see or you concede?
I can see, Your
So
Honor.
you're not conceding?
I think, not exactly, Your Honor. I understand.
Okay, so fine. Make the defense why that's okay. I mean, if you either conceded or you make the argument why that's okay.
I think it was not improper to respond to Ms. McComer's defense that she did do the work.
100% agree.
And I think that comment was responsive to that argument.
Wait, there's lots of things I can respond to, but that doesn't mean anything I say in response to them is okay. That's just a category mistake.
I understand, Your Honor. And look, it towed the line of improper. I'm sure the AUSA recognizes that now. I can't.
Do they?
I have not spoken to the AUSA who made the comment, so I can't say for certain, but I'm sure he's listening to these arguments. I'm sure he's picking up what Your Honors are saying here. The last point I wanted to talk about was the
You're
offsite.
arguing the appeal, but you haven't talked to the lawyers that tried the case?
I've spoken with the lead trial counsel, Mr. Gray, as well as the appellate chief from the office. I believe this was the fraud trial attorney who made this comment. I did want to briefly address the offsite jury instruction. I agree with Judge Heitens that I think this argument was waived here. Not only did the trial counsel say that he was completely satisfied with the instruction, he went on to rely on it in his closing arguments multiple times. Even if the court reaches the merits of that issue, I don't read the instruction as really burden shifting. I read it as communicating to the jury exactly what Ms. McComer wanted, which is that she's allowed to work off-site, and if she billed hours that she did on the contract off-site, the jury can consider that as going towards her actual workable billable hours. To the extent that the court disagrees with that interpretation, I just wanted to note that, I think that instruction needs to be understood in the context of the entire jury instructions, which again made clear from Judge Hollander that the burden of proof is on the government. If the court doesn't have any other questions, we'd rest on our papers and ask that you affirm the judgment below.
Do you all have other questions?
I do not.
All right, thank you.
Your Honor, I'd like to make just 3 points, 2 about the record and the facts and 1 legal. I believe I heard my friend on the other side reference Ms. McComer's billing 8 hours every single day. In fact, that's mentioned frequently in their brief. It is not uncommon for government employees and government contractors to bill 8 hours every day. And I would ask Your Honors to go back
8
and look.
hours on the dot? I mean, what strikes me is, in many ways the single most incriminating fact in this case.
Your
is
Honor.
that day after day after day, 8.0, 8.0, 8.0.
I would ask Your Honor to go to JA 3498 to 3561, and this is volumes 7 to 8, and you will see that this is a printout of all the contractors on Iron Bridge, many contractors, including Jason Doyle, who was one of the government's star witnesses, who they claim did some of her work, 8 hours every single day. That's Jason Doyle, Michael Pierman, Tyler Gary, Samantha Heinlein, 8 hours every single day.
That sounds like a good closing argument that the jury probably took into account.
Your Honor, that was never pointed out to the jury, unfortunately. And then as to whether Mr. Allers, the trial counsel, had a
And
chance
that's
to.
a problem for appellant as well, isn't it? That was never pointed out to the jury on,
That the other employees were billing 8 hours a day?
yes.
It could be a problem, Your Honor, but the fact remains that that doesn't get past the fact that the jury was asked to draw unreasonable inferences, and the jury had that. So the people time details, that was an exhibit that they had with them in the deliberation
And that was
room.
your first fact.
But
Go ahead.
I'm sorry.
No, you go ahead.
But let's assume it's being done a lot. Does the fact that it's being done a lot make it any less incriminating? I mean, it may be that they should have pursued others, but, I mean, we've all, those who have been in private practice have billed hours. If I billed 8 hours a day, I mean, every day, and I'm just trying to think, okay, I did it, but my associates did it too, how that helps me.
Your Honor, I would just say that it's quite different than a lawyer billing in 6-minute increments, and Ms. McComer's testimony was that she frequently worked more than 8 hours a day, but could only put 8 hours on her timesheet. She was obligated under the terms of the contract to work 8 hours each day, and that's what she did. And then the last thing I want to point out is I did hear my friend on the other side concede that the statement in closing was improper, and it was objected to. In fact, the government submitted a letter asking permission to do what it did up front, and the judge held a conference, and the objection was heard, and the judge's position was that Ms. McComer had opened the door to these comments. And then we're squarely in Chapman, not Alano, and the government has the burden to show harmlessness beyond a reasonable doubt, and it cannot be said that the trial outcome would be the same but for that conduct. Thank you, Your Honors.
All right, thank you both for your argument. We'll come down and greet counsel, and unless, do you want me to break?
No, I'm good.
Need a break?
I'm fine.
And then we'll go to our last case. Yeah. All right, yeah, please be seated. I got it right this time. All right, so Gibbons versus Gibbs. Mr. Pershing?
Good morning, Your Honors. May it please the Court. Steve Pershing for Appellant Christine Gibbons. The trial court's exclusionary rulings are the reason that we're here. There were 2 layers of those exclusionary rulings, and put together, they just tied our hands at trial.
Well, can I ask about things that seem like they tied your hands at trial? Can you give me, why in the world did you not depose the defendants before trial? It seems like so many of these challenges stem from the fact that the defendants themselves weren't deposed.
Well, Your Honor, discovery was drastically truncated.
I don't care how truncated discovery is. I could imagine we would want to depose the defendant.
I did very much, and we were unable to
Did
because
the
of
district court
scheduling.
refuse to let you depose the defendants?
No, Your Honor, we only had a very short time to do
Did
it.
you move to compel their depositions?
No, they would have consented, but only at a time when I was unable to do it. There was just no way to
But
have
just be
to do
clear, I
everything.
understand that you think to be clear, the trial court gave you an early trial date, and you didn't object to the trial. And there's this feeling in your brief that, like, the trial court treated us so unfairly by making us go to trial super fast. Now, in general, my sense is that plaintiffs as a group would like to go to trial and would like to go to, but regardless of all, isn't that all atmospheric? You did not object to the trial date, you did not ask the district court to continue the trial date, and you're not arguing on appeal that the district court erred by forcing you to go to trial so early.
Your Honor, we felt we could not. We were the
Yeah, you made
people
a hard
asking.
choice, but that's not reversible error.
We're not contending that the.
Well, you do. You throughout your brief, you sort of complain about the speedy trial date. You say we didn't have enough time for discovery. We didn't have enough. But either you're making an argument that that was wrong, or none of that matters. I just don't think you can do this. Well, we had to do this, and that explains these problems we have.
Well, I don't think we're contending that it was discovery problems that
Well, no,
caused.
to the extent the district court said you can't offer evidence of X unless you can give me some foundation to believe Y, the way we normally do things like that in civil litigation is discovery. That's how we get evidence of Y. And in a case where a party doesn't avail themselves of discovery, they don't seem super well positioned to say we weren't, like, the trial court erred in excluding something because we couldn't link X to Y. Why couldn't we link X to Y? Well, either A, we didn't have to link X to Y, or alternatively, we just didn't have a chance. I need, you know, that is my sense of like why I think virtually everything you're objecting to on appeal stems from the lack of discovery in this case.
Well, Your Honor, the difficulty we have with the two pretrial rulings is not just that the court that the court could not tell whether a showing was made. The court said those because it didn't want to relitigate the 2020 election
But I
on
guess
its
when I look at
merits.
the transcript, what I see Judge Ballou saying over and over and over again is, I'm not going to relitigate the 2020 presidential election. I'm not going to relitigate in general what happened anywhere else. If you can connect it to this situation and these people, I will let you do it. Can you do that? And actually, what I see Judge Ballou saying over and over again is, as of right now, I don't see any connection to these people and this situation. That's what he says over and over and over again in the transcript.
Your Honor, I think the difficulty that he ran into, and he was such a decent judge. We're not, this is not personal, right? But the partisan mistrust we're talking about was kept out on a blanket exclusion.
But I don't see Judge, you keep saying that. When I read what Judge Ballou says, I don't see him saying that. I see him saying, if you can connect it to these people and this situation, I'm open to revisiting this. But what he says is, what we're not going to do is have a global relitigation of the 2020 presidential election or its aftermath. But he says, I think every single time he rules against you, almost, he says, absent the ability to connect it to these defendants and this hiring decision, I'm not letting you do this.
He did not allow us even to.
Right, but isn't your argument that the court did not allow you to make the connection, the very connection that you needed to make to prove your complaint, you weren't permitted to argue?
Your Honor, that is exactly our concern, and again, it's just.
This is a complaint about a politically motivated dismissal, and yet, as I read it, you were not permitted to talk about political motivation.
That's exactly the problem.
Well, is that right?
And
I mean,
I'm sorry, Your Honor.
It seems to me, from my read, there were restrictions about the January 6th event and the 2020 litigation coming in. But you were allowed to produce all the evidence of political activity you wanted about the hiring or failure to reappoint this plaintiff, and all the stuff around, or at least you didn't object to any restrictions about the facts you alleged in your complaint and all that stuff. I mean, I read the complaint again last night. I mean, it's 64 paragraphs, and I know complaints, normally not the end of the story, but you had two things about January 6th. You had 64 paragraphs of all these irregularities that you pointed out around Lynchburg.
Your Honor,
those were political things. That was your case, mainly.
Our contention on appeal is that key motive evidence was excluded, blanket exclusion at the final pretrial conference. And let me put it this way. The judge felt, I think, well-intentioned, that the the claim of motive would necessarily require deciding whether the defendant's grudge about 2020's election result was, had a basis or not. That's not it. You don't ever have to prove that a grudge was baseless.
Why is it an abuse of discretion when you're able to prove and introduce all the evidence you want about these particular defendants' actions with respect to this particular plaintiff, and even these particular defendants' actions in general concerning Lynchburg elections, all those things you, in the 64 paragraphs in your complaint? Why isn't it okay for the district court to say, all right, you want to add to it their views, participation, whatever, in January 6th? But that's an explosive thing, and it may have some probative value, but any probative value is outweighed by the prejudicial impact of that, given that there's so much you could have done about the local election.
Well, Your Honor, I don't think there was a 403 ground that the judge asserted. He asserted it was not relevant. He said that you don't litigate the election result, and our point is that you don't have to litigate the election result in order to decide that a grudge about it motivated these defendants.
Okay, so can I bring us to a more specific level? Because one of the other challenges I have is I have some real questions about whether the vast majority of what you're arguing was preserved. Because what I hear Judge Ballou saying is, as a global matter, I'm not going to allow X, but I might allow Y. So I'd like you to be as specific as you can. What specific evidence, not evidence of blank, I'm not talking about, quote, evidence of blank, what testimony from a witness or what documents are you asserting that the district court improperly excluded?
All right.
A witness was going to say the following sentence. He said they couldn't say it, that level of specificity.
Mostly you get it from the pretrial conference. I have JA 93.
Well, let's go, if you would.
The court excluded any evidence related to.
No. That's not the question I'm asking. What evidence did you want to offer? A witness would have testified blank. A document would have been admitted that said blank. I'm not asking for the scope of Judge Ballou's ruling. I'm asking what evidence do you claim that he wrongfully excluded, that you were ready to go. I had it. I was going to put a witness on the stand. They were going to say X. What is that?
Well, Your Honor, we believe that the evidence that Defendant Gibbs believed the 2020 election was fraudulent. Don't forget the context that Biden narrowly won Lynchburg that year, and certain Republican folks were convinced that she had somehow done something wrong.
And where did you proffer the specific evidence that you believe the district court wrongfully excluded?
The best proffer we have, Your Honor, is in the final pretrial conference. The result of it was a blanket exclusion. If we respect the court's rulings,
And is
we
that
can't
the
then divide
JA
it.
site you just gave us a minute ago?
Yep, and then also JA 100, where that's transcript 39 of the final pretrial, where the court excluded evidence of parallel events in other 5th congressional district counties, which we.
Go ahead, I'm sorry.
Oh, Your Honor, forgive me.
No, you finish your thing, but I do have a follow-up to what you just said.
But what we proffered was that there was evidence that these defendants had participated and/or collaborated in efforts by Republicans in other counties in the 5th Congressional District, that's Steve Troxell's district he represented on the Republican Central Committee, to house their registrars as soon as Republican folks took majorities in those other counties.
So can I
And the judge
follow-
excluded it as a blanket exclusion.
Well, so a couple things. I mean, I think Judge Hyten's question, would apply here, which is there an individual that you were, what individual, what were they going to say? Were you, for example, did you say, I'm going to call these other registrars who weren't reappointed? Did you ever say, I'm calling John Smith, Mary Jones, these are registrars from these counties, they're going to testify about personal knowledge they have?
We'd already named the registrars in other counties who had been ousted. Kelly, forget the name.
Did you put that in the record so the district court knew the specific people that you were going to put on the stand and what you thought they were going to say?
Well, they were on our witness list, Your Honor, and they were disclosed in discovery, but the court gave this blanket exclusion. We couldn't even call them.
Well, didn't he say this on the very page you're talking about, JA 100? I'll let you proffer the evidence at trial that you would otherwise want to put on if you want me to reconsider it. but I would need to know specifically what the evidence is before we get there. And then when you go to the morning of trial, the reconsideration of it, he takes up the motion to reconsider, and there he says, he grants it. He says, so to the extent that the motion to reconsider, no, he says, the motion to reconsider is granted to the extent there's clarification that it wasn't intended to circumscribe specific actions taken by the defendants. So it sounds like he's saying you can ask these defendants things about their actions.
That's not how we understood it at the time.
But
We
how do you-
believed that the
I'm just
judge.
reading it, isn't that what it says?
It does not stand in a vacuum. The judge had already said that any evidence of this collusion or conspiracy was irrelevant as a general proposition. So if we're going to respect the court's rulings, it's very hard to just
You
go
mentioned that
in.
he says irrelevant, and I agree that, and he says irrelevant. There are other parts of the ruling where Judge Ballou says it's a distraction, it's sort of a side issue, it's confusing. All of that is in the language of 403, right?
It is, although
He certainly
his,
says things that are definitely in the language of 403.
well, distraction is one thing. Distraction, I think, is something you can say it sounds in relevancy.
No, it
and
sounds
that's-
in 403, as in evidence, though relevant, may be excluded unless it might bring us down a rabbit hole and risk confusing, and that's classic 403 language.
That's true, but he also said,
No,
I
agree.
think it's irrelevant.
I certainly agree the judge also said that. I
Yeah.
did not dispute.
So, we can't, it's like arguing against a phantom. If the judge says, go,
Well, so
this is irrelevant,
So is,
then you,
if you'd like to identify specific evidence that you'd like to offer, I'll reconsider, and then no one offers the evidence they'd like to offer, and so now we're in a world where, I just feel like I'm stuck in a world in which the parties present, among other things, diametrically opposing views on the question. How would Judge Ballou have ruled had the plaintiff attempted to do X? And the answer is, I don't know, because the plaintiff never attempted to do X. And it feels like on appeal, I should not be wondering how Judge Ballou would have ruled on a specific question when the plaintiffs didn't proffer what the specific evidence they wanted to offer was.
well, Your Honor, we did our best at the final pretrial. He had a blanket exclusion. That's where we were. We would have had to defy him. Let me just focus on the voir dire part of our case, because I don't want to lose sight of that. Springing from this
Great,
judgment
so
that
let me
this...
ask you a threshold question on voir dire. Have you found any case in which any trial court was ever found to have abused its discretion in declining to ask about a potential juror's political preferences or affiliations?
No, and that's
So
a
the
little
answer is-
maddening.
The answer is 0, right?
I haven't found any. That doesn't mean that the standard doesn't apply. The standard is, and this is from Lancaster, a Fourth Circuit case, right? There has to be reasonable assurance that prejudice would be discovered if present. We got to think about the context here. This is a place where the jury is a microcosm of the public. We have to think about the fever that gripped this one political party. That is something we're entitled to probe. As we say in our brief, you've got to be able to look to see if the jurors, the would-be jurors, shared the bias
Well,
we're
you don't,
seeking to
actually.
prove the
So
defendants had.
We all agree, do we not, that there is actually literally no right for the lawyers to ask the jury any questions in voir dire whatsoever. The judge, if it wants to, can say, none of you all are asking jurors any questions, right?
That's true, but that's not what we're dealing with, is an exclusion either of questions we were to ask or questions that the judge would ask. So I don't think that's a problem.
I guess what I'm saying is these cases, again, tell me if I'm wrong, my sense is the cases that reverse for failure to have inadequate voir dire about specific topics are overwhelmingly about race discrimination and overwhelmingly in the context, well, race discrimination and something that would give rise to a challenge for cause, not the exercise of a peremptory challenge. Is that descriptively accurate?
I won't dispute it, but I do think that one of the cases we've got says that at least in the criminal context, that if you deny a challenge for cause, and that is found improper, it won't necessarily be because the challenge for cause would have succeeded if there's also room for a lawyer in voir dire to even if they had to, dislodge a juror using a peremptory challenge, there's still a problem when you prohibit the probing into the matters you mentioned. It seems to me that political bias of this kind in this feverish climate is fully the equivalent of race bias in race cases. This is political bias in a political case.
And I think that's a fair comment, that political bias in a political case is fair game. It's a general matter. But, I mean, look, I'm nothing great, but I mean, in civil cases, go to courtrooms throughout the country day after day after day, and judges aren't allowing specific voir dire questions as the parties want. I mean, I did that over and over and over. In my sort of area, I wanted specifics and just, I mean, judges, it's normal because the judge has to balance a bunch of interests. They have to balance the interest of detecting bias. They have to balance the interest of the length of the trial. They have to balance the interest of the privacy of the jurors. They got a lot going on. And as I read what the district court was doing, and I appreciate your comments, despite your objections to it, your appreciation of the district court, but the district court looks like it's, doing its best to balance all those things. And we have an abuse of discretion standard. That just seems like it's hard for you when he did talk over and over about bias. You wanted more. When I was a trial lawyer, I wanted more. Rarely did I get it.
Your Honor, may I answer? I know my time's up.
Yes, please.
The balance is the issue. Yes, there are many interests to consider, but when this judge decided that the 2020 election was irrelevant, he cut our hands off by saying there's no way you are going to be able to show that a grudge about that election was relevant to this decision not to reappoint. That was key evidence. And then he said, because it's irrelevant to the case, I'm not going to let that, for that reason, I'm not going to let you ask the jurors about it. And our problem is that they harbored that same bias. The denial of those questions was tantamount to allowing those biases into the jury box. That, it seems to me, is on the reversal side of that line. However well-intentioned the judge may have been to try to limit the scope of the trial, it's still true that you don't ever have to prove a grudge was baseless in order to prove someone was motivated by it. I just don't think the relevancy parameters that the judge laid out that we through trial tried to respect were sufficient to bring about the Lancaster reasonable assurance that prejudice would be discovered if present.
Thank you. You
very
have some
much, Your
time
Honor.
in rebuttal,
Thank you.
Mr. Pershing. Ms. O'Brien?
Good morning, Your Honors. My name is Blair O'Brien. I'm here today with my partner, David Corrigan, on behalf of the appellees, Betty Gibbs and Stephen Troxell, and may it please the Court. In August 2024, a jury in the Western District of Virginia considered the appellant's claim that she had not been reappointed to serve an additional term as the General Registrar and Director of Elections for the City of Lynchburg for political reasons. After hearing 4 days of evidence and testimony from myriad witnesses, the jury concluded that the appellant had not proven her case.
Was forgive me for not knowing this in detail, but I referenced with your colleague the paragraphs of the complaint that talk a lot about allegations of activities that happened in Lynchburg, that they referenced in the complaint. Was that type of evidence introduced at trial? Did the plaintiff introduce the evidence or attempt to ask questions about the things generally that are alleged in the complaint?
Certainly, Your Honor, yes. And I can point specifically to the number of witnesses that Ms. Gibbons called, including a sitting delegate in the House of Delegates here in Virginia, who testified to what he witnessed at local Republican committee meetings and the defendants.
Were the witnesses permitted to testify about the, quote, big lie surrounding the 2020 presidential election?
Your Honor, no testimony was solicited from any witnesses in that regard, and so there was...
Because wasn't it excluded by the court? Isn't that what was excluded by the court?
Your Honor, the court did grant the motion in limine as to testimony related to the 2020 presidential election.
Which is
but-
what I just asked about. So, and a motion in limine limits the evidence, so it wasn't solicited because the court had excluded it, correct?
Well, I suppose the court indicated what he believed was going to be relevant
The
and
court
admissible
didn't
at
rule, you
trial.
just said the court ruled on the motion in limine.
The court did grant the motion in limine as to the
Okay.
2020 election.
So tell me how-
I'm sorry, no, you finish. Go.
How is the political motivation not relevant in a case alleging termination due to political reasons?
Your Honor, I suppose I will call back to what my friend on the other side talked about earlier about whether or not this was a 401 or a 403 ruling. And
What did the court say 403?
I believe the court did say 403, and certainly we moved under Rule 403. We argued that it was more prejudicial than probative. and
Well,
likely
I
to
asked
confuse
you
the
about
jury.
relevance, so let's start there. How is the political motivation not relevant in a case that involves an allegation that someone was terminated for political reasons?
Your Honor, evidence of political motivation as to a hiring and firing decision or appointment or reappointment certainly would be. Attendance at a rally more than 3 years earlier becomes a question of whether or not that's
Well,
actually
that
evidence of-
provides the entire context for their theory, for appellant's theory of the case. I'm not saying whether it was right or wrong, but that's the entire context. You've read their complaint, I'm sure. The very first paragraph starts to tell the story and provide the context of what happened here. And the granting of the motion in limine, in my view, cuts out the entire context of the complaint. Does
Your
it not?
Your Honor, it doesn't, and that's because of the quantity of evidence related specifically to both 2020 in Lynchburg and subsequent years in Lynchburg, and even before 2020 in Lynchburg, related to interactions between Republicans and Democrats local to the Lynchburg Republican Committee and Lynchburg elections.
Can I ask you about the piece of evidence whose exclusion is, I'll say, is high on my list of troubling? And that this is Mr. Troxell attends this other meeting in the other county, which shortly after the registers in that county do the exact same thing that they did in Lynchburg. Why is that excluded?
Your Honor,
That seems so let's go to 401. Evidence having any tendency to make any material fact more or less likely. That seems like it definitely has some tendency to make some material fact more likely.
Your Honor, I think as an initial matter, as I believe Judge Quattlebaum pointed out, that ruling was actually clarified on the first day of trial, that evidence specifically related to our clients, to the appellees, was admissible to the extent that the appellant wanted to solicit that information. And as I stand here today, Your Honor.
So you would say as to that, at minimum, given that, at minimum, it was not clear that Judge Ballou would have excluded that particular evidence.
Certainly. And as I was about to say, as I stand here today, I don't know what that evidence would have been. As Your Honor has pointed out, there was very limited discovery here. I'm not sure who or what witness would have been called to testify about Mr. Troxell's presence at any other electoral board meeting, at any other place in the Commonwealth.
I think Judge Quattlebaum had a question earlier, and I talked over.
No, thanks. I had a preliminary, I have these categories in my head as January 6th in one bucket and in the actions with other counties in another bucket. So that, I'm talking, I think there's based on the questions I asked earlier and that what you just said, I think there's a preservation issue about the other county issue and, the fact that it was modified. But going back to the January 6th, isn't it fair to say that the district court, at least in terms of preservation, I'm not asking you about 403, but is it fair, didn't the plaintiff identify specific evidence about January 6th, like post I mean, that was not, that seems to me to be more clearly identified. You know, I'm sure there was some talk about it more broadly, but I think they identified specific posts, I think, from Mr. Troxel. So preservation alone, in the context of that, at least those posts clear enough that that was preserved?
Your Honor, I don't think so, in that perhaps as to the two exhibits that were actually offered in trial, I think it would have been.
Okay.
Kind of hard to say that they didn't preserve their proffer about evidence they actually offered.
Yeah.
Well, forgive me if I've not articulated that well. I do think the two exhibits, I believe they were 82 and 89, that were offered at trial, those, the fact that they were offered and excluded has been preserved. I'm not confident they were actually included in the JA before the court.
I got you. But whether they were, the context was apparent in the motion in limine or when they actually were introduced, that's preserved. So for those issues, at least, you have, it hinges on whether it's relevant and whether the unfair prejudicial value outweighs any probative value. Is that right?
That's correct, Your Honor.
All right. Was there any identification of any other specific evidence about the January 6th other than those exhibits?
Other than those two exhibits that were offered and excluded, the answer to that question is no, Your Honor.
And just so those two exhibits were blog posts by Mr. Troxel?
They were 2 of 3 blog posts by Mr. Troxel. 1 of the 3 was admitted, and there was substantial cross-examination about that third exhibit.
I'm sorry,
There were-
off, I didn't hear.
I apologize, Your Honor. There were 3 exhibits, Your Honor, or 3 blog posts by
Right.
Mr. Troxel that were at issue. 1 of them was admitted and was the subject of significant and effective cross-examination by counsel. The other 2 were excluded as not dealing directly with fraud concerns about the city of Lynchburg.
But that is a clarification, because that suggests that notwithstanding what you're now saying was the morning of clarification, that we can ask the defendants about things the defendants did. Now it turns out we can't actually ask the defendants about some of the things the defendants did, because these are 2 blog posts by one of the defendants.
Well, the blog post that was admitted led to, as I just said, very...
Right, but that, like, that cuts both ways, right? Which is one possibility is, oh, it's no big deal because you got the one. And the other is like, wow, if I was able to really hit him pretty hard with the one, maybe I could have hit him really, really hard if I had all 3. Because, again, I have not read the cross-examination, or at least not in detail or recently, but, like, maybe one of his responses to the one blog was just like, yeah, but that was taken out of context, and yeah, that's that, and that just blah, blah, blah. And he's like, really? Because it turns out that you said similar things 2 other times. Right? I mean, there's an obvious explanation of how getting only 1 of 3 makes the problem worse, not better, because it deprives you of the cumulative effect of all 3.
Perhaps, but I think this goes to what the court has already been discussing, which is the district courts need to balance interest here and to focus.
As you answer that, I want to hear that, but just to understand, I don't think the district court ever, my understanding of what the district court said on the first day of trial on the motion to reconsider is I'll let specific conduct of the defendants about activities in other counties come in. That was about the other counties' evidence, not January 6th.
That's correct, Your Honor.
And so the question, I don't think they ever said you can do defendants and activities about January 6th. I still think that leaves Judge Hyten's questions important. You let one in, but not others, and there needs to be a justification why that wasn't improper.
Well, the one blog post that was admitted was a post directly about election fraud in Virginia, including specifically in Lynchburg, and so that it went directly to the issues of at play when we're deciding whether or not we're going to reappoint a registrar.
So if I understand it, then that's along the lines that I think it sounds like the parties agree on what happened there. That the district court said you can introduce evidence about political bias related to the local activities in Lynchburg, but to the extent you're talking about doing about January 6th. That either is not relevant or the probative value is outweighed by the unfair prejudicial impact?
Well, specifically as to January 6th, the evidence that was suggested in the complaint that I understood may have been solicited at trial was directly related to appellee Gibbs's presence there on
Okay.
that date. There was no allegation and no evidence that I'm aware of that Mr. Troxel was ever there.
Okay.
So if we're talking about Mr. Troxel's statements in a blog post that he made about national election concerns, January 6th was really never at play with him.
I got you. Just, it was the national elections concerns versus the local issue.
Correct. And that line of questioning on cross-examination got into Mr. Troxel's more global feelings about the trustworthiness of members of various political parties, whether or not individuals who were Republicans were more likely to be trustworthy than Democrats as election officials.
That was explored at trial?
It certainly was, Your Honor, yes. There was direct testimony solicited and given on that point. So, again, it goes back to the courts need to focus the jury, because to ask the jury, to suggest to the jury that it needed to resolve questions surrounding the validity of the 2020 presidential election, I think falls.
I don't think that the appellants want to resolve the validity of the 2020 election or not. That's what Mr. Pershing argued when he got up here. It's about the defendant's views of what happened at the 2020 election, and that being a motivating factor for why they got rid of appellant. I think that's where that's what the court thought. I think that's what the district court thought, that appellant was trying to rehash the entire 2020 election thing. I don't think that's what appellant was trying to do, but he can say it again when he gets up here again, I guess.
I suppose, but part of the problem here, Your Honor, is that we are trying to guess what they were trying to do because we don't really know what the evidence would have been. The evidence of even Ms. Gibbs's presence, what that evidence would have been, is not in the record before the court. And certainly the complaint directly read that there was going to be myriad assertions of I guess, irrationality by the appellant. I apologize, Your Honor.
No, I'm sorry to cut you off before you do that, but, I mean, that seems to me less, I mean, maybe that's a preservation issue and you don't know, but it seems to me, given the law that, you know, with the federal rules of evidence changes that allows you to, you know, satisfy the requirements of the proffer requirement without a formal proffer. The district court had a good sense that the plaintiff was going to that the defendants were going to be asked questions about their views of the 2020 election. And maybe you have enough on preservation, but let's assume that was preserved. Mm-hmm. Don't you still, I understood the district court, maybe I'm wrong, to say, look, we got a bunch of evidence about local politics, and maybe the information about, you know, the 2020 election is probative, but it is so inflammatory that it's going to hijack the trial, and it's unfairly prejudicial. Isn't that a fair way of reading the district court's decision?
Your Honor, I hope it's a fair way of reading our motion, because that's exactly what our argument was, is that we believed that there was going to be, and in fact there was, ample evidence related to the appellee's political activities locally in Lynchburg, that the inflammatory, and I think it's important to remember the context of this. This was in August of 2024, in the middle of another very contentious presidential election, that the court was having to make these decisions about what was going to be admissible and what wasn't. And in the context of a case that did have testimony from a sitting member of the House of Delegates about the political activities of the appellees in this case, that had another witness who worked in the
What did the sitting delegate testify to about the political activities of the appellees?
He testified that he was present at Lynchburg Republican City Committee meetings that were also attended by Ms. Gibbs and Mr. Troxel, at which discussions about whether or not registrars should be replaced and how that should happen occurred. So again, that is
Did they, right, but what about their views on the 2020 election being stolen and a fraud and all of that?
Testimony was solicited from Mr. Walker, the Delegate Walker, as to his opinion about whether or not the motivations of the two appellees were political or not. He opined that it was. He didn't specifically address the 2020 election and was not asked about it, Your Honor.
Because it was excluded.
I don't know,
That
because
that
again-
takes us back to where we started this argument.
Yes.
Whether it was excluded or not.
But on that point, I think going back again to Judge Quattlebaum's point of sort of what's the harm here, there was ample evidence related to the activities of the clients and the motivations of the clients, not only just in relation to their political actions and their political motivations, but also the other motivations that they had in relation to making this decision. So if we're talking about what evidence substantiated the jury's verdict here, there was significant testimony about the lengthy relationship between Ms. Gibbs, the appellee, and Ms. Gibbons, the appellant here, and the Office of the Registrar.
But I don't know if that helps you, because that's your defense evidence. Because at a very high level of generality, I understand the dispute in this case to be as follows. The plaintiff asserts that this was part of a fairly organized to some level effort, I'll say, switching the partisan turnover of the various groups of these three people in Virginia to get rid of people like the plaintiff, and that's why they fired her. And your defense was, that's not why we fired her. We fired her because her and this new member of the board hated each other and had hated each other for a long time. And maybe that's right, maybe that's not, but I think their argument, as I understand it, is you're making us fight with our hands tied behind our back because you get to introduce all the evidence that supports your theory, like these two women hate each other, and that's not a partisan, necessarily an improper partisan motive, but they don't get to introduce all the evidence because once you put forward that theory, their obligation, whether as the burden or not, or as just people who want to win their case in front of a jury, is to say, refute the explanation that it's just these two people hate each other, and cool, here's how I'll refute it. I'll show it was part of a broader effort, and their response is, and yet we're not allowed to introduce the broader effort, which means your story, their inability to tell their complete story makes your story look more plausible than it would otherwise. What's the response to that?
I certainly understand that, Your Honor, and I would point
It's
to...
like that summary chart in the prior case, only in trial form. Go ahead.
I was fortunate to listen to that argument before I had this one, Your Honor. I would point to some of the evidence that was brought out from Ms. Gibbs by counsel. There was a Facebook post from 2020 that she was cross-examined directly about activities in Lynchburg, election fraud in Lynchburg, her concerns about the validity of the 2020 election as it was happening at the time.
That relates, if anything, to harmlessness. Despite the fact that it may have been wrong to not let her introduce something else, she got to do a lot of stuff, and maybe it's harmless, but that doesn't really address whether it was an error.
Well, I think whether or not it was harmless and whether or not there was a substantial right that was affected, which is the standard for the court.
Sure, totally. I just think that seems like an argument about harmlessness and not an argument about whether it was error to exclude the other. The fact that she was able to do some stuff doesn't really address whether it was error to not let her do other stuff.
And, Your Honor, I think, again, this goes back to the balancing that the court has to engage in under Rule 403. If we're looking at the undue prejudice, the likelihood of confusion to the jury, and I see I'm about to run out of time if I can finish my response.
Please.
Thank you. This is core Rule 403 analysis, where if we've got all this other evidence and we've got this very large, intractable national issue that we might...
That I get that with respect to January 6 or 2020 election. That to me, that's just me. I can appreciate a judge saying that is removed, even though it's potentially relevant, it's removed enough and explosive enough that we're not going there. But, I think that's a harder argument with the other county evidence. And because that's stuff that these defendants themselves are doing in very similar situations, and it's kind of framed as a conspiracy, and the district court says, we got and the plaintiff's approach to this is, okay, I have circumstantial evidence, and you can prove conspiracies by circumstantial evidence. And, to me, that's a harder argument for you. I think your preservation argument is better, though, and I think the fact that the court said you can pursue that as it relates to the defendant's conduct, but apparently that wasn't pursued, it may mean it was a choice, not an exclusion. But I have a harder time, understanding how similar activity, one county, two counties over, isn't pretty significant evidence if they had it, identified it, and called it.
It's that second part of Your Honor's question that's the problem. I don't know what that evidence was. I used to be a criminal prosecutor, Your Honor, and if I had somebody in a room, within a few minutes or hours or whatever before something happened, you better believe I would be trying to introduce that evidence. But here, I don't know who, what, where, when, why. I just have this generic suggestion that there was this connection. In the absence of more, I can't even make an effective argument as to why it wouldn't be relevant, Your Honor. Thank you.
All right, thank you. Mr. Pershing, you have 3 minutes.
Your Honors, thank you. Just a couple of points. The court is quite correct to notice that the theories propounded in defense of the appellee's decision to fire Christine Gibbons were the ladies didn't get along, sort of the image of two cats not getting along. That was their defense. What we don't have is what started it, because we were not allowed to introduce that.
Well, could you just respond to how your friend on the other side concluded her argument? No, I'm just literally the last thing that your colleague said was, maybe this other county evidence, sure, but in the absence of evidence of who was going to testify, what they were going to testify to happened, it's very hard to assess whether or not that could or could not be excluded under 401 or 403.
We told the judge what the evidence would be.
No, you didn't, because you haven't told me either. You said there will be evidence of a meeting, but that's not who's there, what they said, who's talking to who.
The judge actually said, we said, Gibbs and Troxel were at these meetings, and then after that, the boards of other
Lots of people are at
counties.
these meetings. I can see about, 20 people in this room right now. And I would say, if I was asking someone's role in what's happening right now, I would need to know more than they were in the room.
Actually, the judge said, no, even if you could show that, and even if you could show that afterwards, such and such a vote was taken, Judge Ballou, again, however well-intentioned, he actually said, that's not relevant. He didn't even say 403.
Right.
He simply discounted as circumstantial evidence. We've got to be able
So that's an
to
interesting
introduce that.
question. I'm sorry, Dick.
No, Your Honor,
You
please.
through with that? I asked your colleague that, it's, lots of things, especially conspiracies, sometimes are proved by circumstantial evidence. And so I'm trying to get this straight. That's the way we would look at the conspiracy cause of action. But does the fact that that's the way we would look at a conspiracy cause of action mean when you don't have a conspiracy cause of action, the judge can question whether there's enough evidence of it?
I think,
In other words, are those two one-to-one, are those the same question?
they aren't. Our evidence of other counties goes to motive. The folks who made this decision to fire Christine Gibbons were also about trying to get other counties to do it. That's what our proffer was, and that's what the judge, as I say,
Did you
excluded
ask,
categorically.
and you didn't, the judge said the defendant's conduct is relevant. Did you ask the defendants anything about that?
I think we tried. The problem is the judge had already said,
Is there somewhere where you, in trial, you said, Mr. Troxel, Ms. Gibbs, I want to ask you about, what went over in County ABC? Did that,
no, because the judge had already said it would be irrelevant. That's the ruling we so passionately disagree with. So we were stuck. We want to respect the court.
And the reference where he said you can talk about defendant's conduct, your view is you thought the prior rulings, essentially meant that was not really something he was offering up?
He said no. He said we could not, well, let me say specifically, I see my time's run out. If I may just try to answer this. The judge actually said to us in the pretrial, I don't think it's relevant just to show the circumstantial evidence. That, it seems to me, is on the reversible side of that line, that balance we want to respect.
But then you moved to reconsider, and then when you moved to reconsider, he said you can talk about the defendant's conduct.
But he had already said we couldn't, that it would not suffice to be admissible if we had defendant's conduct, what he really said was, unless you have evidence from somebody who turns and pierces the cone of silence between these folks and says what Ms. Gibbs or Mr. Troxel said to a fellow partisan, unless you have
So unless you have
it's not
direct
admissible.
evidence.
Correct, that's what the judge is basically saying. So circumstantial evidence was excluded, even though in Your Honor's reading, I don't dispute that the judge said in partial, if not clear exactly what he was granting, he already had said, if
But you
you
moved to
bring that evidence,
reconsider.
I won't accept it.
But I just don't get it. You move to reconsider. He says you can talk about the defendant's conduct. You say you're kind of confused about that in relation to the motion in limine reason, which I get. I mean, and I get that, you know, trials are stressful, it's hard to figure out. But, you know, if you say, Judge, does that mean I can ask these defendants about this, or that at the other counties? I mean, you know, it looks to me like he's saying you can ask the defendants about what they did. Maybe he didn't mean that. It seems to me.
Well, the question whether you can ask is different from the question what he would do with it, and we expected an objection and that would be sustained. So we felt completely stuck and robbed of the chance to make circumstantial evidence count.
All right, thank you.
Thank you, Your Honor.
All right, we'll ask the clerk to adjourn court and come down and greet counsel.
This honorable court stands adjourned. Signed, aye. God save the United States and this honorable court.